Next, from Springfield, Brad Cole, Executive Director of the Illinois Municipal League, is joined by Pat Devaney, President of the Associated Firefighters of Illinois, as the two talk about the effort to reinstate the long-standing public duty rule, which states that public workers, such as police and firemen, do not owe a duty of care to provide services to individual members of the general public, and as such, cannot be sued for failure to protect individual members. This runs about 15 minutes.
Hey, I'm Brad Cole, Executive Director of the Illinois Municipal League. I'm joined here with Pat Devaney, President of the Associated Firefighters of Illinois. We're here to talk about an important issue for municipalities and public safety employees. In January of this year, the Illinois Supreme Court essentially abolished two controlling legal doctrines. First was the public duty rule, a principle that was established in 1968 and reaffirmed in 1998. And second, stare decisis, which is the legal foundation for determining matters of litigation according to precedent. In Coleman v. East Joliet Fire Protection District, a lawsuit was brought against public safety providers alleging wanton and willful misconduct and negligence against the plaintiffs. The case involved the unfortunate death of an individual who had contacted 911 for emergency medical services. The common law public duty rule provides that local governmental entities owe a duty to the general public. They owe no duty to individual members of the general public to provide governmental services such as police and fire protection. Instead, they owe this duty to the general public. As stated in the Supreme Court's ruling, it is grounded in the principle that the duty of the governmental entity to preserve the well-being of the community is owed to the public at large rather than to specific members of the community. Even so, in the Coleman case, the court decided to abandon the public duty rule and to abandon the public safety employees who the rule supports and defends. Today, we come together as local government elected officials and public safety employees to ask the General Assembly to reverse this dangerous decision and adopt Senate Bill 3070, which would restore the broad protections previously provided by the common law public duty rule. We seek a statutory change because it was in the same court decision that such a suggestion was made, citing Justice Kilbride, saying, if the legislature determines that the public policy requires it, it may codify the public duty rule, but we defer to the legislature in determining public policy. And so today we ask the General Assembly to do just that, and I'm pleased to introduce Pat Devaney with AFFI at this time.
Thank you very much. I'd like to start off by thanking Director Cole and the Illinois Municipal League for including us in this important effort. And in these unusual times at the state capitol, I think this is a good example where divergent interests can come together in support of something that really is common sense. And that's what this legislation is about. First and foremost, I want to make it very clear. Firefighters and paramedics in the AFFI are committed to serving and protecting the residents of communities throughout Illinois. And we're very proud of that work that we do today, every day. This legislation provides a legal umbrella for both our citizens and the first responders that are sworn to protect them. A firefighter's sole focus always has and always should be the emergency at hand. Every day, we respond to those in need, victims of fire, those in need of urgent medical care, auto accident victims where we provide extrication, hazardous materials incidents, domestic violence, and even domestic terrorism at times. Never should a first responder have to worry about the legal ramifications of an effort to save a life. We need to reinstate an environment that ensures taxpayer dollars are being invested in resources our members use to keep our communities safe. And that's why the Associated Firefighters of Illinois fully supports Senate Bill 3070 and looks forward to working next to mayors, elected officials across the state to support this legislation and urge unanimous support by members of the General Assembly and the Governor. Thank you.
So we'll be glad to take any questions. It's a little bit of a complicated legal issue, but we'll be glad to take any questions on the topic.
So, as I understand it, Brad, if, let's use a police officer as an example. I think there was a case earlier that someone had a order of protection, and yet the woman's ex-husband came over and killed her. The family sued, and the city government argued, we don't have an obligation to save you as any one individual, because any number of things could happen. The president could be in town, an airplane disaster. You try to do your best in both cases, but you may or may not be able to affect success in every instance. Is that basically the nub of the issue?
That is basically it, and as Pat indicated, fire personnel, police personnel, their job is to protect and serve the general public, and that's a job they take very seriously, and we're very proud of them for that work that they do. However, it is very difficult to prepare for all potential happenings at any point in time. There's certainly not the available resources to staff for that or to be prepared for anything that could happen to any one individual in a community. And so this rule protects public safety employees who are looking out for the general well-being of the community.
Without this, could you, Pat, could your members be individually sued?
The answer to your question is yes. We believe that the municipalities would be named, individuals would be named, and that's why this legislation is very important to us. Absent making these changes, we believe we're going to create an environment where there's going to be a cottage industry of frivolous lawsuits aiming to capitalize on the suffering of others, and that's completely inconsistent with the values of our organization and the work our members do every day.
Well, what do you think the Supreme Court intended by that?
Well, the Supreme Court threw out its own decisions in this matter in 1968 and again in 1998, and I think the split decision opens this up. Obviously, there's some disparity in the opinion because the ruling that was issued indicates that. Perhaps they are just asking for a legislative remedy. If so, that's what we're trying to provide. But the bottom line, and I hope that the Supreme Court is not seeking this, but the bottom line is when police and fire personnel are responding to calls, they should respond to that call with the best interest of that individual in mind and the general public. They shouldn't be worrying about whether or not there will be a frivolous lawsuit filed later because they had to stop and help another emergency situation or there was some other critical issue that intervened. The police and fire personnel and our public safety employees should not have to worry about whether they're going to be sued when they respond to help somebody in the community.
Well, I'm thinking about, for some reason, the doctor leaving the scalpel in me, and I'm suing for malpractice. Is there a police or fire equivalent of malpractice that maybe they should be exposed to?
No, there is not, and the basis for this is the willful and wanton misconduct or the negligence, not malpractice necessarily.
And you're not going to protect bad cops or bad firefighters, certainly.
That's not what this legislation addresses, no. This is protecting the police officers and the firefighters who are out there every day doing their job, responding to calls and trying to help people.
And really, it's just reestablishing a principle that we've been operating under for many years. And I'm certainly not an attorney, but if you look at what the court said, it wasn't necessarily they disagreed with any sort of the merits of the case, but they said if the General Assembly intended for the public duty rule to apply in Illinois, then it very much should be codified in statute. And that's just simply what we're doing to operate as we have in the past.
Right.
You're not looking to add anything else? It's just simply restore what was removed?
This is simply restoring what the Supreme Court had previously affirmed and now had reversed, trying to restore that through legislation so there can be no question about it. And as Pat indicated, there's no reason why this should not pass with a unanimous approval through both chambers of the General Assembly and be signed by the governor. This has decades of common law practice behind it and previous rulings by the court. We're just coming together trying to seek a final remedy to this so there can be no more question about it.
You mentioned a cottage industry of lawsuits that you're hoping to avoid. I'm wondering, I know the decision was only in January, but have you noticed an uptick in suits that you don't think would have been brought had this decision not played out the way it had? Or are there particular cases that you're aware of that basically rely on this decision?
I know of no specific case. I mean, it's a very new decision, so I don't think we would really see the results of it. I just know that creating an environment where you're giving an individual right as opposed to just focusing on the greater good isn't something that's necessarily in the best interest of anyone in any community across the state.
Are you aware of any opposition to the bill?
I believe the Illinois Trial Lawyers Association is opposed. Of course, they may be involved in the industry that we were just talking about. But what we're here to do is look out for our residents, the citizens we serve, and to make sure that the general well-being, the health, public safety, and general welfare of the communities are protected.
The bill's currently sitting, being referred to assignments and hasn't moved. We passed the deadline. Are you hopeful that somebody will give it an exception and try and move it?
Yes, we've talked with the Senate sponsor, and I've talked with the Senate president about it. It's been held in assignments, just pending an assignment, and we are confident that we can get it moved.
Can you sort of detail what type of, talk a little bit about misconduct, what types of things wouldn't be protected from litigation in this? So, I guess I'm a little confused between the distinction of misconduct that someone could be sued for versus what they would be protected from if this were enacted as well.
I think the issue is willful and wanton misconduct. So if somebody purposely does not aid or assist when they're on a call, that would be a different situation. But in the general response to a call that the employee, the firefighter, or the police officer is responding, they're doing their job, that's when they're protected.
So if someone ignored a call because they were watching a movie on their phone as opposed to did something that ended up having a bad outcome in the course of the call.
Yeah, and there are many other types of requirements to care. I mean, in your EMT or paramedic licensure in regards to providing patient care and the standards that you would. If you think of it in this context, at times when there's great demands on the system, and if you look at the case, I think there's some evidence of that. There are systems in place where dispatchers are required to prioritize calls based on what's being reported to them, and then first responders use those priorities to respond to them in the order of greatest need. This would allow any individual, based regardless of the circumstances of the significance of the illness or injuries, to be able to believe that you didn't respond according to some type of arbitrary standard, as opposed to responding to meet the needs of the citizens and the community as a whole.
Do you, I'm just going to hand out here when it says the Supreme Court struck down the public duty rule in part because of the application of the rule is incompatible with the legislature's grant of limited immunity. In case, I won't read it all, but the point is, do you not already have some protection according to the Supreme Court ruling? It seems like they're saying you don't need the public duty rule because you've already been granted some legal protection.
There is the Tort Immunity Act that provides some protection to local governments. However, that's an affirmative defense that you have to go and present. There can still be lawsuits that are brought. The municipality or the individuals, if they're named, still have to go make that affirmative defense. This precludes that, and so this is the step that disallows for the frivolous nature of lawsuits to be filed that we anticipate, while there haven't been any in the last couple of months that we're aware of, but we anticipate that there will be numerous lawsuits that are filed. So this law would disallow that and provide that protection before having to go defend against the frivolous lawsuits.
If the public duty rule is in effect, does it invalidate the public's ability to bring suit against egregious misconduct by a public official, by a fireman or a policeman?
Not if it's will and wanton misconduct. If they can prove that, they can, of course, follow that through the courts. But this provides for the general protection of the employees, the public safety officials and public safety officers who are out there every day working on the streets, trying to respond to a dozen different calls at one time, prioritize, as was just indicated, and protect the general welfare of the community. So it protects them in general. Any other questions? All right.
Thank you very much.
Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.